Dr. Staker. I'm told that I was referring to you or addressing you as Dr. Straker yesterday. My apologies. Yes, Mr. Smith.
My lord, my ladies, I've got two more issues to deal with. I'm conscious that I've overrun my initial estimate, so I'm going to take them as quickly as I can. And they are, firstly, the question of whether we can pray in aid immunity to obtain the silver without paying salvage, and whether the receiver can only release the silver if salvage is paid or security provided. So that's the first issue. And the second is the issue of whether we would be able to invoke state immunity in relation to any determination by the receiver of salvage if the receiver has jurisdiction or power to determine salvage. So taking the first issue first, my learned friend Mr. Hoffmeyer's case is that even if we are immune from the jurisdiction of this court, the receiver would be obliged to detain the cargo that had been delivered to him unless and until we brought an action for delivery up, assuming we hadn't paid any salvage. And his
or potentially, Mr. Smith, until the courts in South Africa had determined that there was or was not a claim for salvage, because on your client's case, the only court that can determine that properly are the courts of South Africa. So let's suppose that the courts of South Africa find that there's a time bar and finally determine that there is no claim for salvage. At that point, you could waive the court order under the nose of the receiver and get your silver back.
That would certainly be our position, my lady.
Yes.
And South Africa is, I think it's a matter of record, a signatory to the Salvage Convention, the same as this country.
Yes.
So the provisions that the South African court...
So it wouldn't just be a case of you having to bring an action for delivery up. You would have the option of waiting until such time as the salvors brought the proceedings in South Africa and all of that was determined, and if it was determined in your favour, then you'd be able to get your cargo back then.
My lady, that is indeed a possibility.
Yes.
Although it might give rise to a subsidiary issue of the powers of the receiver of wreck to detain a cargo where the proceedings were ongoing in South Africa. But I will be coming to detain the cargo while proceedings are ongoing.
Yes.
So, my learned friend's starting point, if I could ask the court to have the Supplemental Authorities bundle, tab 9, page 71, is section 226 of the Merchant Shipping Act 1995. I hope all of the members of the court have now received, as requested yesterday, the additional pages for the legislation, so the long title and the contents pages.
I'm not conscious that I have. It's possible that they went to my clerk that he has put them in, but I'm not conscious I have.
I thought they had been made available, but they are being made available.
Lovely. Thank you very much. Thank you.
And my learned friend is right insofar as it goes that section 226 is mandatory in terms. The word used is shall. The receiver shall detain. But the important words that he omits in his analysis is where salvage is due under this chapter in subsection 1, and if salvage is due in subsection 1b. And under this chapter must, in our submission, mean pursuant to the terms of the 1989 Convention on Salvage. And I'll come back to that in due course. But we do submit that unless the claimant can establish that salvage is due under chapter 1, section 226 is not engaged at all. And the obligation to release under section 239 would be engaged instead, provided we had established title. So Argentum needs to show that salvage is due pursuant to the convention given force of law by section 224. In his analysis, my learned friend says that once the services have been rendered, he has a maritime lien.
So I'm sorry to stop so early, but so a claim that it's due isn't sufficient to trigger the obligation to detain under section 226. Is that your case? There must actually be an established.
My lord, I am coming on to address that. At this stage, I'm simply addressing the pursuant to which provision, and it is the convention. So, my lord, can I? I'll tell the court the answer and come on to develop the submission if I may.
Yeah.
Our submission is going to be that looking at section 239, due in the context of section 239 must mean either agreed or established, because 239 presupposes a payment being made, and a payment cannot be made unless the amount of the salvage due has been established, either by agreement or determination. We recognise that obviously the power to detain can't only arise when there's been a determination, otherwise there would be no detention pending the determination, and therefore we would accept that the power to detain also exists while a determination is pending, while there are proceedings pending, whether in this court or, as my Lady Justice Andrews has said, potentially in South Africa. But we would submit that those are the only two circumstances in which the receiver would be entitled to detain.
Where does that come from, if it doesn't come from Section 239?
My Lady, where it comes from, one first of all has to look where there might be a right to salvage, which is why I was starting with where the right would derive from.
Yes.
And then one has to see how that right might be made good.
Yes.
In order to determine at what point the receiver would be obliged to release. And so, my Lady, they are steps in the analysis. So if
I follow that, Mr. Smith, but we're talking about the initial detention. Certainly, speaking for myself, the way that I read this statute is that when a salvor makes a claim to salvage, once the question of ownership has been decided by the receiver of wreck, at least for the purposes of deciding who the claim is going to be made against, the receiver of wreck is obliged to detain until the argument is determined between those two, either by amicable agreement or by arbitration or by a court of competent jurisdiction. And what I'm struggling with at the moment is your analysis, which seems to suggest that due means established to be due, but there's nevertheless a power to detain before the establishment that something is due.
Well, my Lady, I think it comes with respect to the same thing, because we would say exactly as my Lady has said,
yeah,
that the receiver has power to detain until the dispute, as my Lady put it, has been resolved.
Yes.
So
I'm speaking for myself. The confusion arises about over whether you're talking about Section 226, initial detention, or 239, retention. And I had thought your submission was that for the purposes of Section 226, initial detention, it had to be a claim for salvage which was in fact due under the terms of the convention. Had I misunderstood that?
my Lord, yes, no doubt, because I didn't explain it clearly enough.
Yes, well, that's, I think
that was where I was.
In which case, I apologise, was capable of being made good.
Yes, okay.
all right. Thank you.
So that's why I was starting with where the right to salvage would originate from, because that then colours the analysis of 226 and 239. So going back to that analysis, my learned friend's starting point is he has a maritime lien. It's not clear from the section of his skeleton dealing with this point whether he would say he can rely on the maritime lien to justify the detention. But lest he does, I'll come on to deal with that. But first of all, I should make it clear that we agree with my learned friend that in limitation, so time bar cases, that the limitation acts to bar the remedy and not the right, particularly in the Salvage Convention. So that the right can still be relied on as a defence, but only, we would suggest, as a defence. We also agree with my learned friend that a plea of state immunity is procedural. It doesn't remove the right, it simply bars the remedy in this court. But in our submission, none of that means that salvage is due for the purpose of the 1995 Act. One still has to look elsewhere for what creates the obligation to pay salvage. And the first point we would make is that in our submission, it's in the nature of a maritime lien that if the ship is state-owned and not in use for commercial purposes, no lien can arise. And in that respect, could I ask the court to have tab 18 of the Supplemental Authorities bundle, a case called the Survey, which I mentioned briefly yesterday, and I just would like to take the court quickly through two passages. So it's page 248 if one has the bundle animation. And this was a collision case, so I accept it's to do with collisions rather than salvage, but for these purposes it is dealing with the creation of a maritime lien. And the collision involved a ship that at the time belonged to the government of the King of the Belgians and was being run for public purposes. We see that in the head note, the second paragraph, setting out the facts. In terms of the facts, that's all we really need at this stage. But essentially, what happened is the Belgian government then sold the vessel. A claim in rem was brought against the vessel, and therefore it would depend only on a maritime lien. So the issue for the court was whether a maritime lien arose against a state-owned ship. And the relevant part of the judgment is at bundle page 255, judgment page 266, beginning "the point is founded," which is just over halfway down the page. The point is founded partly upon the effect upon the property of the sovereign state if a maritime lien attached to the debate as alleged, and partly upon a consideration of the nature of the maritime lien itself. If the judgment of the President is right, and the President had allowed the writ to issue, if the judgment of the President is right and the maritime lien attached to the debate, the value of the vessel to the Belgian government must necessarily have been affected. How seriously, of course, depends on the amount of the respondent's claim. A vessel to which a maritime lien extends for any substantial amount must necessarily be worth less in the market than if she was free from any lien. In the bold Buccleuch, Sir John Jervis, when dealing with the question of a maritime lien, adopts Lord Tennyson's definition of it as a claim or privilege to be carried into effect by legal process. And he then goes on to say that the maritime lien is the foundation of the proceeding. And then I'm not going to read the rest of that section, but the relevant part of the judgment, the determinative part of Lord Justice Banks's judgment, is at 257 of the bundle, 268 of the report, where he says, "It seems to me impossible, consistently with the law as there expressed, to hold that it's permissible to recognise a maritime lien."
I'm sorry, sir. Where are you on page?
The very bottom of
Bottom. Yes, I'm with you now. Thank you.
Possible that it's permissible to recognise a maritime lien as attaching to the property of a sovereign or sovereign state. I see no distinction in principle between the act of the individual issuing the writ and the act of the law attaching the lien. Each equally offends the rule affording immunity. If this is the correct view of the law, then the appellants are entitled to succeed, because unless a maritime lien attached to the debate when she was the property of the Belgian government, it cannot attach at all. And the other members of the court to the same effect. It may be suggested that this is a judgment at a time when the absolute theory held sway. In our respectful submission, that would be a bad ground for distinguishing in it, because there was an express finding that this ship was in public use, and if one simply said that the ship is immune, whether under the restrictive or the absolute theory, and the end can't attach, that would, in our submission, be a correct statement of the law. And we draw some support from that, from the 3 international conventions on maritime liens.
So just before you leave the case, did either Lord Justice Scrutton or Justice Atkin adopt the same process of reasoning?
My understanding is yes, my lord. I wasn't going to go through all of the judgments, but they also all reached the same result. So, for example, Lord Justice Atkin at 263 starts his analysis in the second paragraph, but in my judgment.
Your Lordship asks a pertinent question. It is quite important to look at all 3 judgments in detail, because they deal with the right to salvage, and they deal specifically with set-off and defence and so forth as well. And all of this is in the context of following the Parliament Belge.
All right. Well, you can elaborate on that
Well,
when it's your turn. And this is one of those very strong courts of appeal of that era, in which those 3 members in particular tended to give their own reasons independently of each other, and therefore what is ratio may need more careful looking at. That's the only reason I asked.
Well, my lord, the ratio had to be whether a maritime lien attached
in the first place.
And all 3 members of the court concluded that it didn't. If my learned friend is going to seek to distinguish it, then I'll deal with that if I may. By way of
right, thank you.
But there was an express finding that this ship was in use for public purposes, and therefore, even if one had been applying the restrictive theory, the same consequence would have followed. And in support of that submission, in any event, we pray in I suspect no more than for illustrative purposes, but the 3 international conventions on maritime liens, which we have included in the bundle, at tabs 2, 4 and 7, it is correct the United Kingdom has not ratified any of these conventions, but each of them provides for salvage to give rise to a lien on a vessel, and each of them excludes ships that would be excluded under the restrictive theory, if I can put it that way, but using slightly different wording. And if I could simply refer the court to bundle page 29 at tab 2, so the 1926 convention provides that this convention does not apply to vessels of war, nor to...
You're ahead of me. Tab 2.
Tab 2, page 29, is the 1926 convention. The convention does not apply to vessels of war, nor to government vessels appropriated exclusively to public service. So that reflects the restrictive theory.
Sorry, I'm not familiar with this convention. What if the convention doesn't apply? What's the consequence? What does the convention do?
My Lord, the consequence is simply this: if it is said against me that the travail only applies because the English court was at that time applying the restrictive theory, I simply make the point that under the 3 international conventions that do deal with maritime liens, the same result would obtain. My Lord,
You may be right, but I can't get all of that out of Article 15 because I'm afraid I don't have an understanding of what this convention does.
my Lord, in which case I won't take up time dealing with it. If my learned friend's submission is that the travail does not apply, then I'll deal with that by way of reply.
All right, thank you.
My Lord, our principal submission is that as a matter of English law, the Court of Appeal authority in the travail is the relevant authority. So we submit that there is no maritime lien, and that reinforces the conclusion that the only basis upon which my learned friend could establish that salvage was due at under either of the relevant sections is by reference to the convention. The relevant provision of the convention, since we've got this bundle open, if we look at it in tab 9 of the Supplemental Authorities bundle, the relevant provision of the convention is Article 12, salvage operations which have had a useful result give rise to a right to a reward, which is then assessed in accordance with Article 13.
I'm sorry, it's my fault. I need to catch up. Where's the salvage convention?
Page 105 of tab 9, my Lord. We have it in the other authorities.
I've got it in the other authorities bundle as a convention, but you're looking at it as attached to the act.
But only because it saved putting one bundle away and putting another.
Which was what I was about to do. Yeah, thank you. So what page?
105.
Thank you.
And so the right to
Sorry.
a reward is at Article 12, salvage operations which have had a useful result give right to an award, and then Article 13 is the criteria for fixing the award. And so were my learned friend seeking to establish that salvage was due, he would have to rely on Article 12 and for the assessment of that award, Article 13. And then moving on in the convention, while we have it open, our submission is simply this. If I have won on state immunity, certainly if I've won on the wider restrictive theory than the strict wording of the Act, so if I've satisfied this court that my clients would be immune, as I submitted yesterday, applying the tests as it is laid out in the Premier Congresso, for example, then I have established that at the time of the salvage operations, the cargo was entitled to sovereign immunity under generally recognised principles of international law. I appreciate that's an if, but these submissions are predicated on the assumption I've won on immunity. And if I've won on that, then by Article 25, my learned friend is not entitled to use any provision of the Convention, i.e. including Article 12, as a basis for seizure, arrest, detention by any legal process of, nor for any proceedings in rem against cargo. And detention by any legal process would, we would suggest, include detention by the receiver of wreck under Article 226, or retention by him under Article 239. So it would not be open to my learned friend to rely on Article 12 to justify the detention.
So the necessary concomitant of all of that is that even if there is no extinguishment of a claim, a substantive claim for salvage, and it's got to be dealt with in South Africa, there's no power to detain the cargo here.
Once it has been established that there is the state immunity, which it would be by this court's ruling if we're right on that, then yes, I mean. The only consequence of that would be that if my learned friend's clients were to bring an action in South Africa, they wouldn't have the cargo detained. They would have to rely on their ability.
Security.
They would have no security. And that brings one back to the observation in the Constitution as to whether it would be proper or improper to assume that the government wouldn't honour a judgment if one were made in South Africa.
Well, their behaviour to date hasn't exactly given one cause for optimism about that, Mr. Smith, but we can't express a view one way or the other.
Well, my lady, with respect, no, their behaviour to date is entirely consistent with an intention to honour any judgment in South Africa, or at least neutral on that issue.
But we don't actually have to decide whether you're entitled to state immunity, do we? I mean, the issue for us is whether or not there is Admiralty jurisdiction in REM over this claim.
My lady, the application is to set aside the claim form on the basis that we have state immunity. My lady is right that the court does not have to decide the Article 25 point for the purposes of this application, but nonetheless, we've been asked to make submissions on what the position would be, and our position would be that if we're entitled to immunity under Article 25, that would prevent any ongoing detention of the cargo.
Right.
And so our submission would be that the receiver was not entitled to detain, the receiver was not entitled to detain the silver if and when we've established immunity under Article 25.
Just pause for a moment, please. That's, if I understood your submission, that's the consequence of two things. First, that the whole power of detention and retention is addressed to claims under this chapter, which means under the Salvage Convention, and therefore can only be a claim based on Article 12.13. And secondly and separately, if you have succeeded on state immunity as a matter of application of the Act, or possibly as a matter of customary international law, terviate, there is no maritime lien, so for that reason also, any entitlement to salvage can only arise under Articles 12 and 13. Have I encapsulated?
So, two reasons why my learned friend must ground his case on Article 12, and if we have immunity under Article 25, that is not open to him to justify the detention. Now, there may come a time where there is, if I can put it this way, an interregnum. So, for example, if this court purely determined the application on the Section 10 grounds, or Section 10.4 grounds, it may not be that I've yet established immunity under Article 25. And so the question would arise, what does the receiver do then when there is no live claim? And that's where we would submit, adopting my learned friend's submission, that the receiver could not detain the cargo indefinitely, and the appropriate course would be to release it to my client. Now, my learned friend, Mr. Hofmeyer, says, no, you'd have to bring an action for delivery up. We say, no, the appropriate response is the other way round. The receiver would agree to release it, and he would have to bring an action to prevent him releasing it. But what we do say is that looking at the Act, the overall position is as follows. If there's an agreement as to the amount of salvage due and no payment, the receiver would sell the cargo under section 227, which we looked at yesterday. If there is an agreement and payment, the receiver releases the cargo under section 239. If there is a determination that salvage is due, whether at first instance or on appeal, but no payment, the receiver sells under section 227 to subsections B or C. And if there is a payment after a determination, the receiver releases the cargo. If there is a dispute, and that dispute is ongoing, there are live proceedings, the receiver retains the cargo, continues to detain the cargo, maybe the better way of putting it, under section 226. But we say, once those proceedings have been determined, i.e. in this case, once the court rules on the present application, the receiver would be obliged to release.
Why wouldn't he be obliged to hold on to it until it was determined by the court that you say is the court of competent jurisdiction?
If further proceedings were brought in South Africa, my lady, as I've said, I could see that the receiver may say, well, that there is now another live proceeding in which this is in issue, and may therefore seek to retain the cargo. Then that would then be a matter that we would have to look at, take advice on, and consider.
But if it were, for example, common ground, that any claim in South Africa were time barred, then you wouldn't have to wait for them for the South African court to say that.
Indeed, my lord. As I say, my learned friend's case is that the silver wouldn't be detained indefinitely because we could always apply for an order for delivery up. We say that's the wrong starting point because if he can't show that salvage is due under the convention for the reasons I've already dealt with, the appropriate course would be for the receiver to release it. But I should say here, even if we did bring an action for delivery up against the receiver, we don't accept that we would necessarily be submitting to the jurisdiction so as to lose our immunity. And that is for two reasons. Firstly, the scope of section 2, subsection 6, which I looked at yesterday, as to whether the claim for salvage really would be a counterclaim in respect of which the waiver or the submission to the jurisdiction bit. But also, and perhaps more importantly, because the Article 25 analysis would still hold good. So if we were to apply for delivery up, my learned friend could not defend or intervene in that action to assert that salvage was due, because Article 25 is engaged by reference to the time when the services are provided. So provided I could establish that cargo had been immune at the time the services were provided, then by Article 25 I would still be able to say to the court, determining my application for delivery up, that my learned friend could not establish that salvage was due.
And just going back a stage to what you say is meant by due in section 239, you say agreed or established as due. Established by a tribunal of competent jurisdiction, is that how you put it?
For the purpose of this debate, I would prefer to say court of competent jurisdiction, but tribunal.
What about an arbitration? What about a binding arbitration in which the time for appealing had lapsed? Would that be a determination?
There would be further complications if there was an arbitration agreement, because there would be issues about whether we could invoke state immunity where we had agreed to refer the matter to arbitration.
No, but if it had been determined in arbitration, would that not be sufficient for the receiver?
Subject to the point as to how that would affect state immunity, yes, that would be a binding determination.
So do you still cavil with my formulation, a tribunal of competent jurisdiction?
Well, my lord, I had envisaged that by tribunal, my lord was suggesting the receiver rather than the court. But a court or tribunal of competent jurisdiction. But we would respectfully suggest that tribunal is unlikely to arise in the circumstances that the court is concerned with, because that would presuppose a submission to the jurisdiction of the
obviously that couldn't arise in practice. State may regard it as quite proper that it performs, it pays such salvage as would be due without insisting on its immunity. It's happy
My Lord, yes.
And it's happy for an arbitration tribunal to determine it.
That would depend on the wording of the arbitration agreement. My Lord is quite right. It would be perfectly possible to say that without prejudice to the claim to immunity from the jurisdiction of this court, we would submit to arbitration.
And in any event, we're construing section 239 not solely by reference to states or immunity.
My Lord, yes. So in that case, I would not cavil with the use of the word tribunal.
You could even have an arbitration in South Africa.
My lady, yes. And then, following on from that, I wanted to deal very quickly, if I could, with the point my Lord Justice Popplewell raised yesterday, by way of testing the argument I was putting yesterday, which is, well, what would happen if the salvor simply retained the property? Because you would then have to bring your action of delivery up. You wouldn't be looking at it in the context of the receiver of wreck. And the simple answer to that is that if the salvor retained the property, firstly, the salvor would have committed an offence under section 236 and be liable to a fine. So section 236 is at page 77. That's the provision that the salvor in Knight fell foul of. Secondly, the salvor would have forfeit any right to salvage. And thirdly, the salvor would be liable to my clients as a civil debt for an amount twice the value of the cargo. So I suspect that the answer would be that my clients would not be too concerned about waiving immunity to claim those sums as civil debt, because there would be no subsisting claim to salvage and a right for my clients to recover twice the value of the cargo. So the pragmatic answer is that that is unlikely to arise in practice. So my learned friend then goes on to say, if we didn't bring an action of delivery up, we would be abandoning the cargo. And he relies on the authority, tab 29 of the authorities bundle, interest in goods. And we agree with the law as set out there, that what he would need to show is, amongst other things, the intention to relinquish rights of ownership. And in our submission, if all we had done was to say we did not want to bring an action for delivery up because of the risk of submitting to the jurisdiction, that does not evidence an intention to relinquish the rights of ownership. My learned friend refers to the Crystal, which is a case where there was notice of abandonment served on the underwriters. If anything, all that does is to emphasise that there needs to be an affirmative act to abandon the rights of ownership or relinquish the rights of ownership. So we say that simply not bringing an action for delivery up would not be sufficient to show that we had abandoned ownership. And again, in those circumstances, the receiver would be obliged to deliver the cargo to us. And just to test the other side of the coin, which is our case as to what should happen if the receiver did agree to hand over the silver, and my learned friend sought to oppose that, and we intervened, once again, he would not be able to establish or assert a claim for salvage for the same Article 25 reasons I've already looked at. And so we could intervene in that action, we would say, without waiving our immunity under the State Immunity Act, see section 2(4)(b), but irrespective of the State Immunity Act, we would defeat his application and the cargo would be delivered to us. So those are our submissions in relation to the first point, whether we could obtain delivery of the cargo. The second point, which I want to deal with even more briefly if I can, is whether we would be immune from assessment by the receiver of wreck. And we say we would be on two grounds. Firstly, relying on Article 25 of the Convention, and this really turns on the same point I've already developed. If the receiver of wreck does have power to determine salvage, that is, as an ancillary power or implied as a result of his power to detain the cargo. If we are right and Article 25 would operate to prevent the receiver detaining the cargo, our submission would be that it would also operate to prevent him exercising the jurisdiction to determine the amount of salvage due. It is correct that Article 25 doesn't specifically refer to that procedural immunity, but in our submission it would necessarily follow, if the receiver did not have power to detain, that any power he had to assess salvage did not exist in those circumstances. And I should make the point that, as my Lord Justice Popplewell pointed out, I did accept that on our main application, so our application in relation to these in rem proceedings, we would not get home on Article 25 if we didn't get home on Article 10. We had no wider right of immunity. That would not necessarily be the position in relation to a determination by the receiver of rec, because it is conceptually possible that we are not immune under the Act, but we could still rely on Article 25. And that would arise if, contrary to the submission I'm about to make, the receiver of rec was not a tribunal exercising judicial functions for the purposes of Section 22. And so that brings me on to the final point, immunity from the jurisdiction of the receiver of rec under the State Immunity Act. Section 1, as the Court is aware, provides presumptive immunity from the jurisdiction of the courts of the United Kingdom. And as we looked at yesterday, Section 22, which is in the Supplemental Authorities bundle, tab 5, page 40, provides that in this Act, court shall include any tribunal or body exercising judicial functions, and references to the courts or law of the United Kingdom include references to the courts or law of any part of the United Kingdom. And our submission would be that if the receiver of rec were determining salvage in the manner that has been considered, the receiver would be exercising a judicial function and would be a body, or tribunal perhaps, exercising a judicial function for the purposes of Section 22. And that, in our submission, would not be a surprising conclusion to reach, because if we were immune from the in rem jurisdiction of the Admiralty Court to assess salvage, it would not be surprising that we were likewise immune from the jurisdiction of an officer appointed by the Secretary of State.
Well, I understand that's your submission, but why would a determination by the receiver be a judicial determination as opposed to an administrative one?
Because in this capacity, the receiver would assume that if the receiver were determining salvage, they would have to do so in our submission in accordance with the Convention, and therefore applying the factors in Section 13. And therefore, any such determination would have to be carried out in that manner. And my Lord, can I just give two examples from other areas where this or a similar question has been considered? The first is General Medical Council and the BBC, which is one of the authorities my learned friends refer to in their appendix. That's in tab 22 of the Supplemental Authorities bundle. And this was a case in which the General Medical Council sought to prevent the BBC airing a programme about disciplinary proceedings that the General Medical Council had taken. And one of the issues was whether the Professional Conduct Committee, the Preliminary Proceedings Committee and the Professional Conduct Committee were exercising a function which was recognised to be a judicial function, even though they were not a judicial body. And the test in the Contempt of Court Act, which was the relevant test, was whether the body was exercising judicial powers of the state, which is a slightly different wording to our Section 22, which is just exercising judicial powers. And we just see from the holding held, although the PCC exercised a function which was recognised as a judicial function and did so in the public interest, and it acted in accordance with detailed procedural rules and had close similarities to those followed in courts of law, was not part of the judicial system of the state. So held, in that case, the Contempt of Court Act did not apply. If I could ask the Court to go to page 336 of the bundle, which is page 433 of the report. And in that case, Lord Justice Robert Walker observed between letters H and J that Mr. Henderson submitted correctly that the PCC of the GMC has to adjudicate in a formal and judicial manner on very serious issues which are of public importance and may have the greatest effect gravest effect on the reputation and career of accused medical practitioner. In our case, obviously, a claim for salvage is not going to have a grave effect on the career of any individual, but it is a significant claim for sums to be paid by the Republic if my learned friend is right. Mr. Henderson was correct.
It's a determination of rights and liabilities.
It's a determination of rights and
Well,
liabilities.
is it? Would it give rise to any issue of estoppel? Of course, it's a decision on rights and liabilities, but public bodies do that all the time. Doesn't mean they're always exercising judicial functions. Well, would it give rise to any issue of estoppel between the parties? I would be surprised myself.
My Lord, I would have to think a little bit about the law in relation to issue of estoppel and come back to my Lord on that, but that, with respect, in our submission would not be the test of whether it was a judicial determination. It is still a determination that determines the rights and obligations of the party. It determines whether the salvor has the right to recover salvage and whether the Republic has an obligation to pay salvage.
For the limited purposes of the function that the receiver is exercising under Section 239, and not for any other purposes.
Which would include engaging the obligation on my client on this deposit to pay the amount determined in order to recover the cargo. So, my Lord, it would involve a determination, firstly, of whether Argentum really were a salvor under the Convention. Secondly, what award was due. Thirdly, the engagement of Article 25 and whether any award was due at all. Fourthly, if an award was due, the Article 18 issues, which I've mentioned very briefly before, that my Lord, the Court will be aware, my Lady Justice Elisabeth Laing won't be aware, but one of the issues that will come up in due course is whether there is any conduct by the salvor which under Article 18 would deprive it of its award or part of it. So all those issues would have to be determined in a way that would resolve whether Argentum was entitled to recover anything, and if so, how much, and the amount my clients had to pay on this deposit in order to be able to recover their silver. So it is a final determination subject to potentially a judicial review of the rights and obligations of the parties.
Is the receiver's decision on ownership also a judicial function?
Insofar as it determines the rights of my client, certainly for the purposes of Section 239, yes, I think I would be forced to accept that it does, because it's a determination of rights. But it's not a determination of obligations, in the sense that it's a step in determining the receiver's obligation to receive the cargo, but it's not equivalent to the determination of salvage issues, because it doesn't define the rights the parties have between each other. It simply considers whether Section 239
Well, doesn't it? I mean, it decides that vis-a-vis these particular salvors, you have the right to, you're the people that they would have to look to pay, and you're the people who are claiming the cargo. Not somebody else.
Subject to the point, my lady, that under the Act, that turn it up again, was the point Dr. Slater made yesterday, that under the Act, any determination doesn't affect the right.
A third party.
Third party.
Wouldn't affect a third party. It wouldn't affect somebody coming in at some later stage and saying, actually, this silver doesn't belong to the Republic of South Africa at all. But so far as your claim for salvage in relation to the detained cargo is concerned, once the receiver of wreck says, well, I'm satisfied that it's the South African government that you've got to look to, that presumably is the end of that, as between you and them, unless a court says otherwise.
Unless a court says otherwise. My lady, yes, because we would rely on that determination as triggering the obligation of Article 2.
Yeah.
The court can still say otherwise, as between you and the salvors.
My Lord, yes.
The cargo may have been released or not released, but you may have had to pay, and you may say, well, I'll now go to court and try and get it back. Get state immunity. We're looking at this in the context of anyone.
Whether it's exercising a judicial
and if the effect of the receiver determining that salvage is due is that you have to pay it in order to get your cargo back, that doesn't stop you then going to the court and bringing a claim against the salvor saying it wasn't in fact due, and we'd like repayment, please. Does it?
That might be difficult because of identifying what the cause of action would be, in the sense of if we pay the salvor, but I can see the same result from a different example.
Money paid under a mistake of law, wouldn't it? It wouldn't be difficult to fashion a restitutionary claim there.
My Lord, one might get to the same illustration by simply saying if we sought to prevent to require the receiver to release it without paying the cargo, or to prevent the determination of others. But for present purposes, my Lord, I think I've accepted my Lady Justice Andrews' that the determination as to ownership would be a judicial proceeding as well. Can I just have one moment? So our submission would be that certainly, as regards any attempt by the receiver to determine salvage, that would be the exercise of a judicial function. As I've said, we've looked at the GMC case. There is just one other authority that I would like to take the court to.
I'm sorry to press you, what is it about what the receiver would be doing which makes it judicial? It wouldn't be making any final determination which was binding as between these parties, if I'm right on my example of a restitutionary claim if need be, or vice versa. It isn't a function which, if it exists, is like in the GMC case, governed by detailed procedural rules. So I'm just not understanding quite what it is about it, if, which I know you say is the false premise, the receiver has power to make the determination. What is it about that determination, which is a determination solely for the purposes of Section 239, which makes it judicial? Is it enough, simply, that it's a decision which must involve addressing legal rights and obligations?
I would put the matter slightly differently. It is enough that it is a decision that involves determining the rights and obligations of the parties, subject to any subsequent action of the kind my Lord may say. And the subject to in our respectful submission doesn't matter, because otherwise, for example, any first instance decision would not be a judicial determination because it may be appealed, or any other decision that could be subject to judicial review wouldn't be. But my Lord, to make that good, can I refer to the other authority I was going to take my Lord to, because it deals with this point?
Yes.
And to put it into context, I ask the court to have tab 11 in the Supplemental Authorities bundle. And that contains the provisions of Section 149 of the Equality Act, and also the provisions of so the section is at 134, and Schedule 18, which has exceptions to Section 149, is at 138 as relevant.
Sorry, you're going a bit too fast. What do you want us to look at?
The Equality Act 2010,
yes.
Section 149,
yes.
Public sector equality duty. A public authority must, in the exercise of its functions, have regard to, the need to, and then various matters are set out.
Yes.
Being one.
Yes.
And then it's page 138 in the schedule to the Act, Schedule 18 to the Act. There are various exclusions, and at 138, Schedule 18, Section 3, Paragraph 3, Section 149 does not apply to the exercise of a judicial function. And that section has been considered in the authority we have at tab 25 of the Supplemental Authorities bundle. So tab 25 is the decision of Sir Nigel Teare in the Queen against the official receiver, ex parte Howard. And the issue in this case was whether the official receiver, when considering the making or otherwise of a debt relief order, was exercising a judicial function, so as to come within the exception in the schedule that I've just taken the court to. And if one looks at the head note on page 478, the last 4 lines, the official receiver took the position that he was exercising a judicial function within the meaning of paragraph 31A of Schedule 18 and was not subject to the duty. The claimant sought judicial review of the official receiver's position. And Sir Nigel Teare concluded that when making a debt relief order, the official receiver, although not a judge, was exercising a judicial function so as to come within Schedule 18. So, and the basis of that, if we see at page 522, paragraph 163. 163 is the start of the relevant section. It is in the nature of civil litigation that it's the judge's duty to determine rights and liabilities of the parties. And if I could ask the court please just to read that paragraph, I need to read it out loud, and then skip down to page 166.
So, just pausing for a moment. 163. The judge there seems to be drawing a distinction between a process by which a person's rights or liabilities are determined with binding legal effect, and decisions which have an impact on or affect one or more individuals. Yes, and then where do we get
next? And 166 to a similar effect. It is clear beyond argument that making a DRO affects the rights of creditors to whom a specified qualifying debt was owed immediately prior to making of the DRO. Indeed, although a DRO may be revoked, I'll stress that in the context of my Lord's suggestion that we might be proceeding to, as it were, get away from the receiver's determination. Although a DRO might be revoked inter alia in response to an objection to the official receiver by a person specified, it is not, in my judgment, inaccurate to say that the DRO determines the rights of such a creditor. If the DRO is not revoked or amended, the determination has the consequences to which I've just referred. If it is subsequently revoked or amended, the creditor's rights are still determined, albeit only as regards the period between making and the amending of the revoked DRO.
Well, this isn't remotely analogous because the DRO affects third parties.
I accept that a DRO accepts third parties, but it is still, the question is the determination of rights and obligations of the parties. My lady, I can't put it any higher than that, other than to say that a determination by the receiver of rec does determine the rights and obligations of the parties, and we would therefore submit that it does come within Section 22 of the State Immunity Act. My lady, of course, is not determinative for the purposes of this appeal, but simply of relevance to the wider issues that the court has raised.
in an immigration case, the Secretary of State, the Home Department, determines whether a person has a right to asylum or a right to stay here. It's not a judicial function, is it? And you may be right, but it just strikes me as slightly surprising that a universal yardstick is that it's a judicial function if it determines the rights of the parties. It strikes me that that might be an apt description of many public law administrative functions.
My Lord, I see that point. Can I simply close by making this point? And it's one I started with. If we are immune to the jurisdiction of the Admiralty Court from carrying out a function, determining whether salvage is due, if so, how much, and if so, whether it should be reduced pursuant to Article 18. There is no reason we would suggest why we should not be equally immune to a determination of those same issues by the receiver of rec. And the fact that that might only be a determination for the purposes of Section 239 would not mean that it was any the less appropriate for my clients to be immune to that determination. So, my Lord.
You've made that one.
Unless I can assist further, and I apologise again for overrunning so substantial those answers.
No, you've had many interruptions. There you go. Thank you. Mr. Hoffman.
Your Lordships will just bear with me one moment while I rearrange. Lord, my lady, is just some housekeeping to begin with. I was asked what has happened to the in personam claim. The position is that the in personam claim was issued, permission to serve out was granted. The solicitors for the Republic of South Africa were asked whether they would be permitted to accept service without prejudice to jurisdiction arguments, but they said no. Service was not immediately attempted due to settlement negotiations which were at an advanced stage. When those negotiations failed, an application was made to extend time for service, and the application succeeded, and the process of service through the Foreign Process section of the Foreign and Commonwealth and Development Office commenced. This process, I am instructed, can take many months, even years. I was asked, secondly, moving on, to deal with the correspondence between...
Sorry, just before you move on, when was the in personam claim issued? Will the same time bar arguments arise?
Yes.
When was it issued?
I'll need to remind myself of the...
I think it was November 2020, my Lord. It was the week before the hearing in front of Mr. Justice Teare, or thereabouts.
And why would that claim not be time barred? Given that I think the latest point at which you say the salvage operations were terminated for the purposes of Article 23 was the 2nd of October 2017.
Yes. The reason in that regard would be that, or the argument that would be put forward would be that the Admiralty action had commenced within time, and by reason purely of the procedure in the relating to Admiralty claims in rem, those proceedings could not be amended in order to bring in an in personam claim, and separate in personam proceedings had to be issued as a consequence. And the argument would be that the time bar was interrupted by the Admiralty claim, and that was sufficient for the purposes of the in personam claim.
And whilst I've interrupted you, can I just ask something else which has occurred to me? The time limit under the Convention is expressed to commence from the moment of the termination of the salvage operations. That's when the 2 years starts.
Yes.
Under Section 10, we're concerned with when the cause of action for salvage arises.
Yes.
I know there's a difference between you as to when the time bar runs in this case, that is to say, when the salvage operation's terminated. But is that the same question, or is the answer to that question the same as when the cause of action arises? Or does the cause of action in salvage arise when the bars of silver are salved bar by bar from the seabed?
Your Lordship, with respect, has put his finger on a terribly important point in this context, and that is that the words in section 10, at the time when the cause of action arises, leads people ordinarily to think in terms of limitation and to therefore look at the last moment in time at which the final consummating act, as it were, happens, which gives rise to a claim based on the cause of action. So for limitation purposes, yes, it is that last moment in time that is relevant. And this was clearly what was accepted by the judge below, we say that the proper interpretation of the words when the cause of action arises relates to when those facts that give rise to the cause of action arose, and therefore it's for that reason precisely he said that events in 1942 were relevant, because, and I'm going right ahead of myself here now, I'm sorry, but I'll come back to it in much greater detail. Events in 1942 were relevant because you have to have a maritime adventure in order to have a claim in salvage. And therefore, when you look, even with historic rec of 70, 100 years, at why salvage is permitted in those circumstances or arises, it is because there was a maritime adventure which is part of the cause of action giving rise to the right to salvage. And for that reason, you look at in use or intended for use when the cause of action arose, and you have to, because it's a salvage claim in relation to historic wreck, have regard to a long period, look at the position, the status of the cargo in the ship, and 1942 when the voyage took place, which gave rise to the need for salvage, and is an essential ingredient of the cause of action for salvage. That occurred in 1942. You get the status of the cargo. Is it, in section Article 25 terms, is it commercial cargo or non-commercial cargo? Answer quite clearly, it's commercial cargo. That status is then the status for the purposes of salvage, because otherwise you don't have a right to salvage. That's the purpose, the status for the purpose of salvage, and nothing has happened until after 2017 to change that status. And that's how the judge got to the position he did.
Well, I understand that, but we're looking at your cause of action in salvage,
yes.
And one ingredient, you say, is the previous existence of a maritime adventure. But that's not the only ingredient, and your cause of action depends on salving the silver itself, and does it on conferring a benefit. So you say, I think, your cause of action arises at the same point of time as time begins to run. That is to say, on the 2nd of October when it's brought to England. Is that right? Rather than when it's brought up bar by bar from the bottom of the sea.
Certainly, in that context, so far as time bar is concerned.
Well, I'm not asking about time bar. I'm asking about,
in relation,
when you have a claim for salvage, when you have a cause of action.
I'm sorry.
And I have been looking at it rather simplistically. You may think that you don't have a cause of action until all the ingredients necessary for that cause of action have been undertaken. And as it seems to me, the cause of action can only have arisen at the earliest when the bars are taken up from the seabed, and possibly later when the benefit is conferred on the 2nd of October. But if those are the rival considerations, then it's just the same as the dispute for limitation purposes. There's no difference, as it were. It's when the salvage operations are completed and there's a dispute about whether that's in June or October.
In relation to when the claim arises, that is the correct approach, yes.
Well, when the cause of action arises for Section 10 purposes.
Well, the cause of action is completed, so you have to have all the ingredients in place for the cause of action to be completed and a claim, for it to be possible to assert a claim based on that cause of action.
Well, can one then say that a cause of action has arisen before the last of those ingredients has taken place?
No, but if one asks the question, what is the time when the cause of action arose, one, for the purposes of we say, if one is coming, and I really perhaps need to
I may have taken you out of your turn.
I'm coming to this tomorrow, later this afternoon or tomorrow only, but at the time in order to assess whether the ingredients of the cause of action are in place finally at this point in time, doesn't mean that you look at everything just at that moment in time.
Well, I understand that submission. You may have ingredients that happen at different times, and for any particular ingredient, you may have to look at the time at which that occurred.
Yes.
But I was on a slightly different point, which is whether you would accept that in Section 10, the expression "when the cause of action arises" means when the last of the ingredients which is necessary to give you an entitlement to salvage takes place.
No, we don't. We say that in order to make sense of the section, one needs to give it a purpose of construction. Otherwise, if it were otherwise, historic rec would never come within Section 10(4).
Right.
And
that may be the result of the correct construction of the statute. It may be a totally unpalatable construction, but nevertheless it seems to me to be the natural concomitant of Mr. Smith's argument, if he's right. You can't get a claim in Admiralty for historic rec.
that is right.
If you're right about that, you're going rather further than the judge did. The judge did, as I understand it, regard himself as having to decide what the position was in 2017,
Yes.
albeit that was heavily informed by what the position was in 1942. He wasn't treating the question as anything other than what is the position when the cause of action arises, which is 2017. But you're suggesting that the cause of action arose before 2017, are you?
No, I'm sorry. It's my inelegance I am. What I'm saying is entirely what your Lordship has said as a description of the judge's understanding of it. And the position is at 2017 when the cause of action arises. But in order to assess what the position is in 2017, one has to have a regard to each of the ingredients of the cause of action.
That I entirely understand. I entirely understand, and you're going to go on to develop that. But I think you are accepting, aren't you, that when the cause of action arises in Section 10, it means you've got to look at the position when the last of the ingredients arises, i.e. sometime in 2017.
I am, yes, but I am saying that, as your Lordship put it, that position is informed by what happened prior to that.
Yes.
And particularly in the context of a salvage claim for historic wreck, it's not good enough just to say, well, the ship's not, it's not a ship anymore, and it's not cargo anymore because it's at the bottom of the sea. Because for a salvage claim, what is relevant is the maritime adventure which gave rise to the entitlement to a salvage award.
Yes, I understand that, and you're going to develop that, and I hadn't meant to take you out of your, out of your turn on that. I was more interested in whether there was any distinction between the beginning of the limitation period and when the cause of action arises. But I think you say not.
No.
No, thank you.
And your Lordship is quite right to pick me up, because I did, in the beginning of my answer, say that one needs to look at them differently, and so I should have just simply said yes and then explained. I do apologise.
No need.
Correspondence between the parties and the receiver of wreck, that is being put together with a chronology, and hopefully will be agreed so that you can have that. The table of comparisons between the 1995 Act and its predecessors is almost agreed. There are just one or two loose ends that are being looked at by both my juniors and Mr. Smith's juniors, and when we've completed that exercise, they will be shared with Dr. Straker, and he'll be asked to agree with those if he can.
Right, thank you.
Sorry to ask it will probably seem a very ignorant question, Mr. Hoffmeyer. Is there any reference to the importance of the concept of a maritime adventure in the Salvage Convention?
The Salvage Convention, Authorities bundle divide 3.
I happen to have Schedule
Well,
11.
perhaps I can deal with it this way. I'll come back to it in greater detail.
Yes, well, if you're going to
But
deal with it later on, please
the-
don't let me interrupt you now. Can I just flag that up? With
Salvage as a concept depends upon, arises out of maritime adventures. And it's well understood around the world that that is what is a fundamental aspect of the right to salvage. And again, I'll come to all of this in my submissions in due course, if I may.
Of course.
On the last occasion, I began, I've had 30 minutes of my submissions already, I began on the public international law principle of restrictive immunity and its reception in the United Kingdom and under English law. Thereafter, I had promised to address what I considered to be the two primary issues which arise on the appeal. There are now, in fact, more than two. Although the landscape has since changed, and although I will need to address the additional issues which arise under the Merchant Shipping Act, and as to the meaning of the words ship and cargo in section 10.4, my submissions on the primary issues have not changed, perhaps become more focused and refined. So the structure of my submissions before your Lordship and Ladyships is as follows. First, I will complete what I was going to say on the restrictive theory and draw the threads together on the principle and its reception in the United Kingdom and under English law. Second, I'll address the issues which arise under the Merchant Shipping Act and its predecessors. And as we said on the last occasion, it has been and remains our view that the Merchant Shipping Act provides a complete resolution to the underlying dispute between the parties, whether or not the receiver has power to determine salvage and whatever the true meaning of section 10.4a. Third, I will address the issues which arise on the appeal formally. Four issues of construction appear to arise. with respect to the State Immunity Act. And then there is the inevitable application of the law to the facts as found by the judge, and the facts as found by the judge are not under appeal, nor are you being asked to make additional findings of fact. If one has regard to the amended grounds of appeal, it is not a simple task to separate the trees from the undergrowth, or to tell in what logical order the trees should be approached. And for that reason, I have sought, on a single sheet of paper, to set out the grounds in what I consider to be a logical order. And those highlighted yellow are the new grounds, additional ground A and additional ground B, and whilst they're described in the grounds of appeal as alternative to the primary case, they are clearly the primary case, and in truth, it's at its simplest, it is being asserted that Section 10 does not apply to REC for the reasons in Ground A and Ground B. It is fair to say that there was a similar argument under Ground 3.1, if I can call it that, of the original Notice of Appeal, which is that it was inappropriate to have regard to 1942, that the relevant time was when the cause of action accrued. But that yellow shows the fundamental shift that has taken place in the case. Second, if 1942 is relevant, then there are in truth three matters which the court needs to consider. Ground 1, which is the argument that the silver was not in use for commercial purpose in 1942, that the judge erred in giving undue weight to the silver's use or intended use in 1942, and third, that the judge erred in holding that there was no reason to conclude that its character or status had changed by the time the cause of action accrued, and there are four arguments that are advanced in that context.
The judge didn't address whether there had been a change in status in relation to the vessel, did he? He didn't address that question directly. He decided that the vessel was a commercial, well, it was common ground that the vessel was a commercial vessel in 1942. Yeah. And he decided that that informs the question as to the position at the time the cause of action accrued. He said, so far as the cargo was concerned, status could only change if there was a decision, and on the facts there was no decision by the cargo owners in this case.
Yes.
But he didn't apply that, did he, to change of status of the ship?
Well, because it wasn't being suggested by anybody that there had been a change in the status of the ship.
Really? It's got a different owner.
The argument purely was that it was not in use because it was on the seabed.
Right. But if the judge's approach was a permissible one, that you've got to look at the position in 1942
yes.
to inform the question of whether the vessel is in use for commercial purposes in 2017.
Yes.
Did he not need to address the question as to whether the status had changed?
Well, the mere change in ownership would mean a change in ownership, but nothing beyond that.
Well, but I'm not suggesting change of ownership is conclusive, but it was, in the words of the Brussels Convention, a merchant ship,
Yes.
when it was employed in carrying the cargo.
Yes.
By 2017, it had not only sunk to the bottom of the sea, but its owners had made a claim, hadn't they, on the insurance, and it was now owned by the UK government.
Yes.
Is that right?
Yes.
So for 2017 purposes, is the inquiry what use was being made of the ship by its then owner, that is to say the UK government?
No argument to that effect was advanced, and if it were advanced, we would say that it was a merchant ship when it sank, and its status hadn't changed thereafter. There was no evidence as to anybody having formed a different intention in relation to it.
Well, the intention we're looking at for these purposes is the intention of the UK government, as the owner.
We'll come. That raises
All right.
a different question. Which I need to come to.
You can come on to this.
Time.
Whilst you're identifying the issues, I think speaking for myself, I would derive assistance from a question as to whether there had been a change in status of the vessel, as well as the question as to whether there had been a change in status of the cargo, because, at least as I understand it, that's a necessary inquiry, even on the judge's approach that you start with 1942.
Yes, and there are no findings to the effect that there was a change in status.
Well, or not, because I don't think the judge addressed the question.
No, or he didn't address it because he wasn't asked to address it.
Right.
Apart from as an aid to working out precisely what the issues are, the document is produced to show the fundamental change of position between the first part of the hearing and now. Grounds A and B, which are framed as alternatives, are nothing of the sort. They are the primary contentions, and they've been raised for the first time during the adjournment. They're wholly new. They are, moreover, effectively a single ground of appeal, because ground B is just ground A with a minor
so what?
reduction in scope.
So what?
The relevance of it is, and as again I will come to this, is because my learned friend made very well thought through submissions in relation to what the law was and what the position was, and those ultimately.
You've already made the point that there's been a flip and a flop in relation to whether the vessel was in commercial use in 2017. But so what? We've got to decide what the law is.
I understand that entirely.
I mean, to a certain extent, I think Mr. Smith's clients were driven into the position that they now adopt by us, because to an extent, as a result of some of the questions that we asked, and my lord had rightly raised the question of what the position was with REC, they went away and rethought, and we are where we are. But we have to deal with the issues that are put before us now.
Anyway, you're going to deal with these issues in this order, is that what you're telling us? And we will take whatever we want to from the fact that there's a large amount of highlighting in the first half of them.
As they're now stated, the issues fall into broadly two categories, as I've identified. Whether Section 10 applies to REC, either as a matter of construction or in practice, and this is the big issue. There's no getting away from the unpalatable consequences identified by either learned judge, but also by my Lady Justice Andrews. It doesn't apply to REC. The alternative to that first, as I've indicated, and there's very little to it, is set out at paragraph 2 in those. The 5 issues of construction which arise concern the meaning of the word cargo, the meaning of the word ship, the meaning of the word in use, the meaning of the phrase in use for commercial purposes, and it may be the case also that it arises in relation to the words carriage. And then finally, the key question is whether the ship and cargo were in use for commercial purposes at the time when the cause of action arose, which is the ultimate question. Perhaps remarkably, some common ground remains. First, the Republic concedes that it is liable to pay salvage in principle, assuming there is a good claim and that jurisdiction could be established, as the judge records in the judgment.
Well, to whoever is the salvor, put it that way. It doesn't accept that it's a liability to you.
No, and it raises Article 18
Quite.
issues as well. And, second, but that's relevant in the, come back to that. Second, the Republic accepts that at the time of her sinking in 1942, the ship was both in use for commercial purposes and intended for use for commercial purposes. Adopting the convention language, it was a merchant ship. And until service of its amended grounds of appeal, the RSA accepted further that as the ship remains on the seabed, it's logical to proceed on the basis that her status in 1942 is a continuing status and should determine her status in 2017. That's their skeleton argument, Core Bundle 3, page 43, paragraph 56.
Once a merchant ship, always a merchant ship, even at the bottom of the sea.
And during the hearing, Mr. Smith's words, because it was in actual commercial use in 1942, we would accept that that colours its status still and justifies the conclusion that it's in use for purposes of section.
So, I don't understand why you're making this submission. That's no longer common ground, and we've got to decide the question.
No, I understand that. And in our submission, and it's worth doing this at this stage, we submit that that was all done as a consequence of feeling the force of the judge's observations, Core Bundle Divide 8, at page 101 to 102, paragraphs 121 to 123, and I wondered if I could invite your Lordship and your Ladyships to remind yourselves of those paragraphs in the judgment, 121 to 123. And the concession, we say, was made tactically in order to draw the sting of these paragraphs, but in the light of the flopping back, they apply with full rigour.
Does a vessel only become wreck if there's an intention to abandon all parts of her? The reason I inquire is that, leave aside historic wrecks, that Mr. Justice Teare is concerned with his example of a vessel which is unsalvable as a vessel, but has a salvable cargo, and that's perhaps the main area in which he expressed surprise, as it were, that there should be immunity. But I wonder whether even in that case there wouldn't be parts of the vessel, even if it was going to be broken up as a wreck and had no scrap value, which the owners might want to remove. Would that stop it being a wreck?
It would be a fact-sensitive inquiry as to whether they had, using the Lusitanian language, abandoned the vessel or not, and if the position was that the owner had said, well, we recognise it's a CTL, but we want the ship's bell to be preserved, and we want to, then it may not have the ship's bell on that analysis won't have become derelict and won't have become wreck.
But there may be all sorts of bits in the engine room that would be useful as spares for the other vessels in the fleet or whatever.
Yes.
Which the owner thought they would extract, even though the hull itself, as it were, and the rest of it, was regarded as wreck and was intended to be abandoned and would have to be towed away for wreck removal without any thought of a benefit by way of scrap value.
Yes.
And that would prevent it being a wreck, wouldn't it?
That would
At
prevent,
least until they were removed.
that would prevent the vessel from being a wreck.
Yes.
Yes.
So I mean, I'm just wondering whether, in modern day terms, this is quite such a large problem as might first appear.
Well,
Wow.
in modern day terms, it's become more of a problem in that people are able to get deeper and deeper into the sea, and as a consequence, there is far greater. The question of historic wreck is arising much greater than it would have been.
I understand that. But conversely, if wreck depends upon a determination that it's being abandoned because it's never going to be salvageable, i.e. no hope of recovery, the increase in salvage techniques make it increasingly less likely that a current vessel which founders, if I put it neutrally, will be treated as a derelict, which then doesn't give rise to the problems that the judge had in mind.
Well, it does, because in the example that your lordship has posited, assume that the ship goes to the bottom of the sea 2 kilometres down, and the owner says, oh, I've got the ship's bell that I really want, and I'm not abandoning the ship because I want my ship's bell, and it takes 10 years to solve that. In those circumstances, the use to which the ship is being put and the use to which is again, it's not being put to any use at all. It's at the bottom of the sea.
Well, there's an intended use for commercial purposes, namely the salvage of parts of the vessel. Well, that doesn't give rise to a problem, does it?
Well, again, yes, but all that does is prolong the period of the in use for commercial purposes.
But that meets the judge's problem, as it were. The problem is, if it's wreck at that stage, and therefore not in use or intended use for commercial purposes, you'll never be able, even in relation to salvageable cargoes, to satisfy the conditions of Section 10.
Yes.
Either in rem or in per se.
Yes.
But if the ship owner, because of the prospects of salvage of any part of it, intends that such salvage shall occur at some point, it's not wreck, properly so called, and the vessel is in intended use for those commercial purposes, isn't it?
That's absolutely right, but we're not into, on that hypothesis, the argument is that the section doesn't apply to wreck. It's accepted that the section applies to that which is not wreck. And therefore, if the correct analysis is, in a case where there has not been an intention to abandon parts of the vessel continues to be a merchant ship in use for commercial purposes, and in those circumstances there would be no immunity, and the issue just doesn't arise.
Well, that's what I'm pushing. This isn't necessarily the answer to what we have to decide, but just looking at what was obviously very much in the judge's mind,
yes, in
relation to current wrecks rather than historic wrecks.
Yes. I
wonder whether it's actually a problem which is likely to arise to a great extent. I'm not saying it can't, and if it can, then that's a problem. If that's inconsistent with the
yes.
restrictive theory. But
I'm less bothered by the practical problem. I can see entirely the force of what my lord says. It may be that in reality it's less of a problem, certainly as regards stranded vessels, than it is in relation to the increasing number of historic wrecks that are now being salved. The problem I have with it, I think, is a much more conceptual problem, which is the idea that the question of whether a state can claim sovereign immunity or not should depend on the state of mind of a third party, namely the owner of the ship. So if the owner of the ship takes the pragmatic commercial decision that he doesn't want anything more to do with his wrecked vessel because he doesn't think it's commercially worth paying the salvage for it and decides to abandon it, the state gets a free home pass. But if he thinks that he wants to go and salvage the bell or some useful equipment, they don't. Well, speaking for myself, I think that's absolutely bonkers, because it can't possibly be in line with the restrictive theory of state immunity at all. There's got to be, if one goes back to the sort of basic justification for state immunity, it's that other states shouldn't be interfering in something which is essentially a matter for the sovereignty of the state itself. And I don't see how that can turn on the decision of a third party as to whether or not to abandon their ship.
With respect, my lady, that's precisely our case.
Yes. But the difficulty is, how do you get around the language of the statute? Because the statute seems to me to be flying in your face on this.
Well,
at the time when the cause of action arises, the ship and the cargo aren't being used for anything.
Well, again, that one is and I'll come to deal with this in detail later, but that is a statement, a snapshot at a particular moment in time in 2017, when that doesn't help you establish that you've got a right to salvage, because actually your right to salvage depends upon this cargo having been carried on a ship at a prior time, 1942, and it's only if you dislocate the claim from the source of it that you have the problem under the statute. But if you don't dislocate it from the source of the claim, then you don't have a problem, and that's what the learned judge did, and that was why we say he was right. And it provides a neat way of dealing with a statute which doesn't give rise to unfortunate consequences, which resolves the problem that my lady has so eloquently identified.
But you'd accept, would you, in theory, that the use of a vessel can change over time? It can cease to be merchant and become sovereign, or vice versa.
If it's, breaking that down, if it's still being traded, if I could call it, if it's still being used as a sailing ship, yes, it can be used for a voyage and then be for merchant purposes, and then the sovereign can say, no, I need that now to carry nuclear missiles or whatever.
Yes. So well, the statute you accept requires one to look at the use at the time the cause of action arises, and if that means that the most important thing is to start with the historical use and then see if there's been a change. That's the approach you're advocating, both for ship and for cargo. But nevertheless, one has to look at whether there's a change of use.
Oh, absolutely. And the judge, and we don't, we're entirely content with the judge's finding in that regard. And indeed, those were our submissions below, that the position in 1942 is not on its own determinative. It is simply a factor which comes into play in assessing the position as at 2017. And in the alter, to which I'll come later, Mr. Justice Gross dealing with this, he uses the language of status of the cargo. And indeed, I will submit that if you have regard to Article 25, what the Convention is dealing with is status of cargo and ship. And therefore one's looking at the status in 1942 and asking oneself, well, has that status changed? And in the grounds of appeal, three reasons are given as to why the status of the cargo, 4 reasons are given as to why the status of the cargo changed between 1942 and 2017, and I'm going to need to address those. But no submissions are made that the status of the vessel changed between 1942 and 2017.
Well, I think they are. You use status as the shorthand to describe it, but the statutory language is use.
Yes.
And I think it is suggested that it's accepted that it was the vessel was in commercial use in 1942, and it's not accepted. Indeed, it's argued otherwise, that the vessel was in commercial use in 2017. So it does seem to me that the argument necessarily involves suggesting that the status has changed, because the use has changed. I mean, you keep saying this point isn't taken against you, but it seems to me inherent in what Mr. Smith is arguing.
The argument goes no further than, by reason of becoming wreck, its status changed.
Yes, there's no reliance placed on the change of ownership per se.
Or change of intention on the part of the owner.
Well, Mr. Smith's point is that the merchant venture, such as it was effectively brought to an end by the casualty.
Yes.
And the moment the ship's at the bottom of the sea, it's not in use for any purpose.
Yes. And the difficulty with that approach is that then you wouldn't be able to claim salvage at all.
Yes.
Because and there are cases that deal with wreck on the seabed and ask the question, well, were they in danger? Were salvage services appropriate in the circumstances? And the cases say, yes, of course they are.
Well, there's no doubt that salvage is claimable in relation to the wreck and the cargo. But the question is whether it's claimable in this jurisdiction.
But with respect, my lady, why is it claimable if the ship is simply a piece of tin lying at the bottom of the sea? The hypothesis is that the maritime adventure has come to an end. As a matter of English law, in order to found a claim of salvage, the maritime adventure is a key ingredient of the cause of action.
But not the continuation of the maritime adventure.
Yeah.
is what you're saying. Hence the Lusitania, the Thetis,
Correct.
all those cases in which
Correct.
salvage is recoverable for recovery from the seabed.
And indeed, the very fact that salvage is recoverable in those cases confirms that position. But it's the marine adventure at the time before the sinking, and the fact that the adventure has come to an end does not mean that you no longer have a right to claim salvage in respect of services rendered to salvage either parts of the ship or parts of the cargo. And perhaps this is the right moment. When I was come to deal with the issues of construction which arise, I was going to identify a number of propositions of law which we say are matters which inform and educate the issue of construction. But before I resume with the restrictive theory, if I may, I will just state 5 of those propositions. I won't expand upon them or explain them at this stage. I'll come back to doing that. But I do think that it may be helpful to have those in mind. And the first proposition is a ship and her cargo that have been abandoned by her master and crew without any intention of returning to her are derelict and as such wreck, both at common law and within the definition of wreck in the Merchant Shipping Act. Proposition 2, a ship and her cargo are wreck whether they remain afloat or sink. Proposition 3, the law of salvage applies where 5 ingredients are present. First, where in maritime circumstances. Second, there is a recognized subject of salvage. Third, which has come into a position of danger necessitating a salvage service to preserve it from loss or damage. And 4, a person falling within the classification of salvors. 5, is successful or meritoriously contributes to success in preserving the subject matter from danger. So for salvage of cargo, there must be 1, a ship, 2, cargo on the ship, 3, a maritime adventure during which the ship and cargo have come into a position of danger necessitating salvage services to preserve them from loss or damage.
Why does there have to be a maritime adventure if it got sunk in port before it set off on its maritime adventure? Surely you could claim salvage then.
There are cases which deal, and I'll come to that, which deal with that, but the maritime adventure, and I'll expand on this later, is essential because at common law there is no right to salvage for, and the particular case where it was claimed, which I'll come to later, was where parts of a jetty, from recollection, but I need to remind myself of the fact, parts of a jetty had been affected by the sea or the river tide and had become dislodged and floated down the river, and they were picked up and a claim for salvage was made, and the law said no, it's not a maritime adventure, this is a peculiar right
It's a jetty, so it's not a ship.
No.
For a start. Or cargo on a ship.
Well, again, I think that a maritime adventure is not narrowly interpreted as a voyage. A maritime adventure concerns ships and cargoes plying their trade. So it's too narrow a definition to be concerned only with a voyage.
Your formulation was in maritime circumstances,
Yes.
Correct.
which is not quite the same. No.
And the fourth was the salvage provides the services, and in the case of a contractual salvage, there'd be a contract as well, but not in common law salvage. And the maritime circumstances, as I've said, are an essential element of the entitlement to salvage. That was proposition 3. Proposition 4, salvage and the law of salvage applies to both ship and cargo on a maritime adventure or in maritime circumstances, even where they come within the definition of wreck. Proposition 5, salvage and the law of salvage apply to wreck no matter how long it has been wrecked. Let me pick up then where I left off on the last occasion, on the public international law principle of restrictive immunity. It was received first into the common law and then into statute, and I was dealing with the common law on the last occasion. Let me begin, I'm going to go back to Bencarbuche and Premier Congresso, but let me begin in Bencarbuche, which is Authorities Bundle 1, Divide 17. And I was going to invite you to turn to paragraph 8 on page 368. Before 1978, state immunity was governed in the United Kingdom by the common law. Properly speaking, it comprised two immunities whose boundaries were not necessarily the same: an immunity from the adjudicative jurisdiction of the courts of the forum and a distinct immunity from process against its property in the forum state, that is, immunity from enforcement. And then over the page at A to B, by 1978, however, the position of common law had changed as a result of the decisions of the Privy Council in the Philippine Admiral and in the Court of Appeal in Trentes. These decisions marked the adoption by the common law of the restrictive doctrine of sovereign immunity already accepted by the United States and much of Europe. The restrictive doctrine recognized state immunity only in respect of acts done by a state in the exercise of sovereign authority, iure imperii, as opposed to acts of a private law nature, iure gestionis. Moreover, and importantly, the classification of the relevant act was taken to depend on its judicial character and not on the state's purpose in doing it, save in cases where that purpose threw light on its judicial character, and reference is made to Premier Congresso. And then at paragraph 10, Lord Sumption explains its reception into statute. One purpose of the State Immunity Act 1978 was to give effect to the Brussels and Basel Conventions and thereby enable the United Kingdom to ratify them. It did this in both cases in 1979, but by this time the conventions had been largely superseded by the adoption of the restrictive doctrine of state immunity at common law. So that by way of general introduction. Then back to Premier Congresso, which is at divide 9 in the bundle. close of day one, I was referring, sorry, it's not divide 9, it's, sorry, yes it is, divide 9. I was addressing your Lordship by reference to the speech of Lord Wilberforce, which begins at page 189. And this is the case, we say, in which Lord Wilberforce gave the definitive statement about the scope and principles of restrictive immunity at common law. And beginning at page 192, we start where Lord Wilberforce sets out the law, and an interesting starting point, D to E, is the irrelevance of statutes to the content of customary international law. If one state chooses to lay down by enactment certain limits, that is by itself no evidence that those limits are generally accepted by states, and particularly enacted limits may be or presumed to be not inconsistent with general international law, the latter being in a state of uncertainty without affording evidence of what the law is. And then over the page, at page 193, at D to E, we see criticism of the distinction between in rem and in personam claims drawn by the Privy Council in the Philippine Admiral. It's very much similar to those of Lord Denning from the Court of Appeal, and picking up a D, he says, sitting in this House, I would unhesitatingly affirm as part of English law the advance made by the Philippine Admiral, with the reservation that the decision was perhaps unnecessarily restrictive in apparently confining the departure made to actions in rem. In truth, an action in rem as regards a ship, if it proceeds beyond the initial stages, is itself, in addition, an action in personam, namely the owner of the ship. The description in rem, denoting the procedural advantages available as regards service, arrest and enforcement. It should be borne in mind that no distinction between actions in rem and actions in personam is generally recognised elsewhere, so that it would in any event be desirable to liberate English law from an anomaly if that existed. In fact, there is no anomaly and no distinction. The effect of the Philippine Admiral, if accepted, as I would accept it, is that as regards state-owned trading vessels, actions whether commenced in rem or not are to be decided according to the restrictive theory. And then over the page at 194, Lord Wilberforce, we see him setting out the principled basis for restrictive immunity at C to E. It is necessary to start from first principle. The basis upon which one state is considered to be immune from the territorial jurisdiction of the courts of another state is that of par in parem, which effectively means that the sovereign or governmental acts of one state are not matters upon which the courts of other states will adjudicate. The relevant exception or limitation which has been engrafted upon the principle of immunity of states under the so-called restrictive theory arises from the willingness of states to enter into commercial or other private law transactions with individuals. It appears to have two main foundations. A, it is necessary in the interest of justice to individuals having such transactions with states to allow them to bring such transactions before the courts. B, to require a state to answer a claim based upon such transactions does not involve a challenge to or inquiry into any act of sovereignty or governmental act of that state. It is, in accepted phrases, neither a threat to the dignity of that state nor any interference with its sovereign functions. So we have there the two basic rationales for the doctrine, the interests of justice and the fact that such claims don't threaten the dignity of the state or its sovereign functions. And then immediately below it, E to G, we see the test for the dividing line between the two categories of acts, iure imperii and iure gestionis. When, therefore, a claim is brought against a state, skipping the part in parentheses, and state immunity is claimed, it is necessary to consider what is the relevant act which forms the basis of the claim. Is this, under the old terminology, an act iure gestionis, or is it an act iure imperii? Is it, again skipping the parentheses, a private act, or is it a sovereign or public act? A private act meaning in this context an act of private law, of a private law character, such as a private citizen might have entered into. Now just pausing there and running ahead of myself. So when a state behaves in a way that one might expect a private person to behave, say by putting a cargo purchased commercially on board a commercial trading vessel pursuant to a commercial contract of carriage, and then having the benefit of commercial salvage, they would not expect to have the benefit of state immunity, which by its nature attaches only to sovereign acts. It was at this point that my Lord Justice Popplewell raised the important question, which he described as perhaps the nub of this: what is the act which we're talking about? And with respect, again, he was entirely right. And I promised to return to the question the following day. Events changed the course of this appeal. And I continued with what Lord Wilberforce said at 195C to D, and I will promise to come back and answer that question if I've not already done so earlier today. At 195C to D, we see Lord Wilberforce referring to the phrase coined by Lord Denning in the Court of Appeal, once a trader, always a trader, and set out a vital qualification, and that's worth investigating. We start with the following caution on 195. An assertion, once a trader, always a trader, may be an oversimplification. Then further down, if a trader is always a trader, a state remains a state and is capable at any time of acts of sovereignty. The question arises, therefore, what is the position where the act upon which the claim is founded is quite outside the commercial or private law activity in which the state has engaged and has the character of an act done jure imperi? The restrictive theory does not and could not deny capability of a state to resort to sovereign or governmental action. It merely asserts that acts done within the trading or commercial activity are not immune. The inquiry still has to be made whether they are within or outside that activity. And then we see a comment on commercial obligations in the context of shipping law and the international law of international sale of goods at D to E. In many cases, the process of deciding upon the character of the relevant acts presents no difficulty. In the Philippine Admiral, once it was accepted that the contract for good obligation to repay disbursements and the charter party were of a trading or commercial character, the breach of these obligations was clearly within the same area, nonetheless because committed by a state. At once other reported shipping cases are of the same character, and the Chark here is referred to, which is a collision case, but also relevantly the Porto Alexandre, a salvage case, a case which should have been decided the other way. And just pausing there, and I'm sorry to interrupt, but I think it's worth dealing with that particular point at this stage. The Porto Alexandre, I'm going to come back to Lord Wilberforce, is in a Supplementary Authorities Bundle 1 at Divide 17. The Porto Alexandre was a Portuguese state-owned trading vessel. She came into the Mersey and got stuck in the mud. She was salved by 3 Liverpool tugs, apparently without a salvage contract. Certainly none is mentioned in the report. When Portugal refused to pay salvage, the salvors commenced proceedings against the vessel. The Court of Appeal eventually held that the English courts could not hear such a claim based on what was subsequently described as the misunderstanding of the Parliament Bilge. But it's not the conclusion which concerns us. It is that Lord Wilberforce expressly states that the matter should have been decided the other way. That is, that Portugal should not have been held to be immune, notwithstanding the fact that the Salvos claim did not depend on any positive act, commercial or otherwise, done by the vessel. It does not say, for example, that as Portugal's ownership of the vessel was the only fact giving rise to the claim, that Portugal was immune from a claim in salvage. Now, why is this the case? For two reasons. First, because the maritime circumstances is an essential ingredient of the cause of action. And second, because its restrictive immunity does what its name suggests. Acts done within trading or commercial activity are not immune. And if it were otherwise, a state could in every case claim immunity from common law salvage, an outcome which would be inconsistent with the restrictive theory. The relevant activity that gives rise to the claim in salvage is that the owner of goods has exposed itself to the risk of salvage through its involvement in the maritime circumstances.
So putting it another way, and a bit more simplistically, Mr. Hofmeier, if a state puts goods on board a commercial ship, merchant ship, it's engaging in a commercial venture and exposes itself thereby to a claim for salvage if something goes wrong.
Absolutely, and
Yes.
that's with respect.
Irrespective of what it intends to do with the goods once they get to the other end of the voyage. So even if it's bullion that's going to be used for smelting, for coinage, they're not being put to a sovereign use while they're being carried on the vessel. It's all commercial, no state immunity on the face of it, and why should it differ if the vessel is hit by a missile or something and ends up at the bottom of the ocean?
In summary form, absolutely right. And the arguments that we were having to address against that was that, well, the cargo wasn't in use because it was just sitting in the ship, etc. And I'll come and address those arguments in much greater detail, because with respect, those arguments are hopeless in context. We'll come back to that.
Well, I suppose it could be said that a ship which is stuck in the mud in the Mersey isn't actually being used for anything at the time when it's stuck.
No, I mean, in one sense that's right. In another sense, it's still being deployed
As a ship.
As a ship, and the owner would want it to be sold, to be rescued from the mud in order to continue with the maritime adventure. And I'm going to go back to, you can put the Parliament Bilge to one side, and I'm going to go back to Premier Congresso, but just before that, turn one tab earlier in the bundle to tab 8, Premier Congresso in the Court of Appeal. Along the same lines, page, if one goes to page 169, just below the heading 15 in the first column, we see Lord the Master of the Rolls endorsing his earlier statement on the scope of restrictive theory in another case, Rahimatullah, and he says, where he said, at the present time, sovereign immunity should not depend on whether a foreign government is impeded directly or indirectly, but rather on the nature of the conflict. Is it properly cognizable by our courts or not? If the dispute brings into question, for instance, the legislative or international transactions of a foreign government or the policy of its executive, the court should grant immunity if asked to do so, because it does offend the dignity of a foreign sovereign to have the merits of such dispute canvassed in the domestic courts of another country. But if the dispute concerns, for instance, the commercial transactions of a foreign government, whether carried on by its own departments or agencies or by setting up separate legal entities, and it arises properly within the territorial jurisdiction of our courts, there is no ground for granting immunity. And then back to Divide 9 and the speech of Lord Wilberforce, page 195. And I interrupted myself at E to F, just above F, where he continues, in Trentex, similarly, and the same is true of the acts in issue in other countries relating to the Nigerian cement purchases, the relevant act was simply a breach of a commercial contract and was treated as such, nonetheless though committed by a state or department of state for reasons of government. The purpose for which the breach was committed could not alter its clear character. So we see here Lord Wilberforce is looking at the acts inherent in the particular factual matrix. Where there is an absence of a sovereign act, he considers the matter to be essentially commercial, such that the state is not entitled to immunity. And we see that confirmed at 199, just below B. The conclusion which emerges is that in considering under the restrictive theory whether state immunity should be granted or not, the court must consider the whole context in which the claim against the state is made, with a view to deciding whether the relevant act or acts upon which the claim is based should in that context be considered as fairly within an area of activity, trading or commercial, or otherwise of a private law character in which the state has chosen to engage, or whether the relevant acts should be considered as having been done outside that area and within the sphere of governmental or sovereign activity. And we can then see, page 200, how he applies this to the player lager, and if we pick up at G to H, where he's dealing with the player lager, sorry, I've just lost my reference. Whether the Republic of
Well, the real key is the quotation from Mr. Justice Robert Goffersey then was at the top of 201 at C, isn't it?
That's correct, I'm sorry.
That's the nub of it.
Correct. Whether the Republic of Cuba can claim immunity depends, if I'm right, as to the law upon an examination of those acts in respect of which the claim is asserted. The appellants are certainly able to show as a starting point that the vessel was engaged in trade with the consent, if not with the active participation of the Republic of Cuba. They were doing business with a foreign government, to use the Victory Transport formulation. The question is whether the acts which gave rise to an alleged cause of action were done in the context of the trading relationship, or were done by the government of the Republic of Cuba acting wholly outside the trading relationship and in the exercise of the power of the state.
It's that latter bit of that sentence that
Indeed.
matters. It doesn't just have to be acting outside the trading relationship. It has to be an exercise of the power of the state, which is why I commend, with respect, what Lord Goff said.
Yes.
It's not just that the purpose or motive of the act is to serve the purposes of the state, but the act is of its own character a governmental act, as opposed to an act which any private citizen can perform.
Yes.
And that's the nub of it.
And that's a quotation which I was going to come back to later, but we've got it on the record now, and absolutely. And in it continuing, from where I was reading, in my opinion, it must be answered on a broad view of the facts as a whole, and not upon narrow issues as to Cuba's possible contractual liability. And then he continues, does this characterization of the act of the Republic of Cuba in withdrawing Playa Larga and denying the cargo to its purchasers as done jure imperi? In my opinion, it does not. Everything done by the Republic of Cuba in relation to the Playa Larga could have been done, and so far as the evidence goes, was done as owners of the ship. It had not exercised and had no need to exercise sovereign powers. It acted as an owner of the ship, would act through Mambisa, the managing operators. It involved no governmental authority. And then the top of page 201, A to B, it is precisely to protect private traders against politically inspired breaches or wrongs that the restrictive theory allows states to be brought before a municipal court. It may be too stark to say of a state, once a trader, always a trader, but in order to withdraw its action from the sphere of acts done jure gestionis, a state must be able to point to some act clearly done jure imperi. And from this, the speech of Lord Wilberforce, we say that 5 relevant propositions of law may be derived. And just for your notes, we've set those out in our skeleton argument, and so I'll take them relatively quickly. First, application of restrictive immunity depends on, quote, an examination of those acts in respect of which the claim is asserted.
Could you just give me the paragraph number in the skeleton so I can follow this?
Sorry, yes, certainly.
Dealing with it quickly. Is it the first skeleton or the new skeleton?
It's the additional skeleton, and it's paragraph 41.
Thank you.
Yes, paragraph 41 on page 175 to 6. I'm so sorry, it took me time to get there.
Thank you.
And we put in the references to the speech of Lord Wilberforce. The central question is 199G, whether the relevant acts were done in the context of a trading relationship or were done wholly outside the trading relationship and in exercise of the power of the state. Second, each of the acts to which immunity does not attach is, quote, an act of a private law character such as a private citizen might have entered into, 194MG. Sovereign acts to which immunity does attach take place wholly outside such private activity and in the exercise of the power of the state. The duality is therefore not so much between sovereign and commercial acts as between sovereign and non-sovereign acts. Third, when determining the relevant acts, whether the relevant acts are sovereign or non-sovereign, it is not enough to look at the acts themselves. The question 200A must be answered upon a broad view of the facts as a whole and not upon narrow issues such as the state's possible contractual liability. In other words, 199C, the court must consider the whole context in which the claim against the state is made. Then fourth, once a state has committed itself to commercial acts, such that it cannot claim indemnity from claims arising therefrom, then in order to change that position, it must revert to acting as a sovereign, and that's 201B. It may be too stark to say of a state once a trader, always a trader, but in order to withdraw its action from the sphere of acts done iure gestionis, a state must be able to point to some act clearly done iure imperii. And then fifth and finally, when undertaking an assessment of this kind, what matters is the character of the acts themselves. 201c, the intention behind those acts is irrelevant. And to complete the picture, and hopefully I can do that quickly before the luncheon adjournment, back to Benkar-Boucher Divide 17 and to page 383. Having shown by reference to the cases the way in which customary international law considers the restrictive theory, Lord Sumption comes at 383E, paragraph 37, to consider whether the starting point in conceptual terms is one of absolute immunity subject to exceptions or restrictive immunity properly so called. And he sides emphatically with the latter. And I quote, "The fundamental difference between the parties to this appeal concerns the starting point. On the footing that customary international law must require the United Kingdom to treat Libya and Sudan as immune, the Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognized exception to it. This submission, if it is correct, would considerably broaden the scope of state immunity in customary international law by extending it to any group of claimants about whom there was a diversity of state practice. But in my view, it is not correct. The rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority." Yesterday my learned friend Mr. Smith suggested that the reverse is true. In our respectful submission, he was wrong. And if he had recognised that he was wrong, he would have answered my Lord Justice Popplewell's question posed to him at that point differently. And then at 392, in the judgment of Lord Sumption, he states that the third point that can be derived...
Sorry, which paragraph number?
Page 392, the paragraph numbered 52.
Thank you.
And at C to D, he set out the points that can be derived from the history, and this is the third point to be derived. The adoption of the restrictive doctrine has not proceeded by accumulating exceptions to the absolute doctrine. What has happened is that governments, courts and writers of authority have been prompted by the widening scope of state operations and their extension into commerce and industry to re-examine the true basis of doctrine originally formulated at a time when states by and large confined their operations in other countries to the classic exercises of sovereign authority. The true basis of the doctrine was and is the equality of sovereigns, and that never did warrant immunity extending beyond what sovereigns did in their capacity as such. And then he quotes from Lord Wilberforce a passage to which I've taken you already. And from this authority, a sixth relevant principle can be derived, and that is when applying restrictive immunity, there is no assumption that the state is immune. Immunity will only attach to wholly sovereign acts. And these six principles, taken together, establish what restrictive immunity requires and provide its principled underpinning, at least so far as the English courts are concerned. And just again, interrupting myself, in the light of these authorities, there can be little doubt that the courts applying common law would have concluded that the Republic is not immune from the court's adjudicative jurisdiction. In short, the Republic purchased the silver on commercial terms, placed it as cargo on board a privately owned commercial vessel in accordance with a commercial contract of carriage, and had it subjected to commercial salvage. What is missing from the factual matrix in the instant case is any act done by the Republic solely as a sovereign act. From the time the silver was purchased to the present day, well, until 2017, the end of it, the Republic has done nothing that could not be, well, sorry, to this day, has not done anything that could not be done by a private person. No immunity attaches, and that is the end of the matter.
Can I put to you something that's in my mind, and you can come back and deal with it after
Thank you.
short adjournment. We're concerned with 10.4a, proceedings in rem, although obviously we have to have in mind the ramifications for 10.4b. And so far as use of the vessel is concerned, that's something which is dealt with in both of them. But so far as use or intended use of the cargo is concerned, the only way in which that can maintain immunity, if I can put it that way, is in relation to proceedings in rem, 10.4a. That's the only subsection in which it comes. And what we've been looking at so far is what the principles are in relation to the claim as a whole. But it may be that for the purposes of looking at what's meant by use or intended use of the cargo, which doesn't have any bearing on whether there's immunity for a claim in personam, but only whether it has an effect on immunity for proceedings in rem, what we then need to look at is, well, what is it about proceedings in rem which is here being addressed? And that is not detention, seizure, enforcement. That's all dealt with under section 13. It is simply that the ownership of the raise confers jurisdiction. That's the only adjudicatory aspect of in rem proceedings, which makes them different from in personam proceedings. And that therefore focuses simply on the ownership of the raise by the state at the time, well, actually at the time of suit, but per 4a, let's say, at the time the cause of action arises. So that one's not concerned with all the overlay in relation to what the activity is which confers the cause of action. Actually, for 10.4a purposes, and at least for the purposes of looking at what the use of the cargo means, the element of the restrictive theory that matters is simply ownership by the state. And what is suggested by section 13 is that ownership for the purposes of detention, enforcement and so on is sovereign. And it may therefore be that ownership is the sole activity of the state that we're concerned with for the purposes of use of the cargo in 10.4a, and that prima facie mere ownership is sovereign. That's may not be right, but I just want you to address that rather than assume that, as far as I'm concerned anyway, one can simply import whole scale all the restrictive doctrine into the aspect of 10.4a, which is peculiar to the in rem jurisdiction as opposed to the in personam jurisdiction. Anyway, you can come back to that at 2 o'clock. Thank you.